Thank you, my Lord Chief Justice. I will proceed to read my judgment as follows. I have had the benefit of reading in draft the lead judgment by Alphonse C. I agree with the analysis, decisions, conclusions, and orders that are supported in this judgment. The background to this appeal and the respective cases for the parties to the suit have been ably articulated in the lead judgment and in other judgments prepared by Myland Fiscal and Brother in this appeal, which I have also had the benefit of reading in draft. It is therefore not necessary to reproduce the same. I will only add my opinion regarding the issue relating to the capacity of the I will only add my opinion regarding the issue relating to the capacity of the General Court Martial to render a fair trial, as said in Article 28(1) of the Constitution of Uganda. The jurisdiction and competence of the said court is challenged by the respondent in this appeal. The appellant, on the other hand, contends that it is a court of competent jurisdiction provided for under Article 210 of the Constitution of Uganda and Section 197, now 195 in the voice jurisdiction, the year 2023 of the Uganda People's Defense Forces Act. The appellant also, in opposition to the respondent's assertions, contends that the establishment of the General Court Martial does not contravene Article 28(1), 126(1), 129(1), 210 and 267(1)(b) of the Constitution of Uganda. The General Court Martial is created under Section 197, now Section 195 in the revised version of the laws of Uganda, of the Uganda People's Defense Forces Act. Its long title reads, among other things, that it is an act, I'm quoting, to provide for the regulation of the Uganda People's Defense Forces in accordance with Article 210 of the Uganda Constitution and for other related matters. It is a specialized court in the sense that it was created to exercise jurisdiction over specified matters relating to offenses created by the UPDF Act, committed by members of the military forces and persons who are to abet such offenses. In short, to administer military justice in Uganda with jurisdiction to handle offenses specified in the Act, namely for penal and disciplinary purposes. The General Court Martial was therefore established as a specialized court of the military forces. On the other hand, the Constitution also establishes courts of judicature empowered to exercise judicial power with various jurisdictions under Article 129 of the Constitution, which states that the judicial power of Uganda shall be exercised by the courts of judicature, which shall consist of A. The Supreme Court of Uganda, B. The Court of Appeal of Uganda, C. The High Court of Uganda, and such subordinate courts as Parliament may by law establish, including Cadiz courts for marriage, divorce, inheritance of property, and guardianship, as may be prescribed by Parliament, through the Supreme Court, the Court of Appeal, and the High Court, shall be superior courts of record, and shall each have all powers of such court. And 3, subject to the provisions of this Constitution, Parliament may make provisions for jurisdiction and procedure of the courts. Both the courts martial and the courts of judicature therefore have their origins from the Constitution, save that while the Constitution directly sets up the courts of judicature under Article 129, the courts martial are set up by an Act of Parliament as mandated under Article 129(1)(d) and 210 of the Constitution. The criteria for appointment of members who sit on the General Court Martial, set out under Section 195 in the revised version of the Laws of Uganda 2023 of the UPDF Act, is that they should essentially be army officers, with the chairperson not being below the rank of a lieutenant general. Save for the chairperson of the court, Martial Appeal Court, who is required to be an advocate, qualified to be appointed as a judge of the High Court. Legal qualification is not a basis for appointment on the General Court Martial and the other military courts set up under the UPDF Act. In contrast, under Article 143 of the Constitution of Uganda, persons qualified for appointment as judicial officers to the courts of judicature as established under Article 129 of the Constitution of Uganda must have legal qualifications. It is to be noted that both the General Court Martial and the courts of judicature, particularly the superior courts, under the respective laws that govern them, as well as the penal laws, either in the exercise of their original or appellate jurisdiction, are empowered to pass the death penalty, which is the maximum punishment a court of law will pass. It is also noted that under Article 123(b) of the Constitution of Uganda, the Director of Public Prosecutions, who is the officer charged with the function of, among others, instituting criminal proceedings against any person in that court, is exempted from instituting such criminal proceedings in a court martial. The contradictory position is that while under the UPDF Act, qualification for appointment to the General Court Martial does not require one to have legal qualifications, persons qualified for appointment to the position of a judicial office in the courts of judicature are required to have legal qualifications under Article 142 of the Constitution. Secondly, the conducting of criminal trials in the General Court Martial, unlike in the case for courts of judicature, is not controlled by the Director of Public Prosecutions. The interests of justice and fairness require that any court that is empowered to pass a penalty for a penalty as serious as a death penalty, or even, I dare say, imprisonment, should be presided over by competent persons with legal qualifications. The criminal prosecutions conducted before such courts should ideally be controlled by the Director of Public Prosecution. This would be a safeguard for a fair trial envisaged under Article 28(3) of the Constitution of Uganda. In addition to the International Covenant on Civil and Political Rights, which Uganda is signatory, and all other international human rights instruments, binding or persuasive, which have been ably highlighted in the other judgments to this appeal. In my considered opinion, it would not matter whether in actual fact, that is de facto, the members appointed to sit on the General Court Martial, in the wisdom of the appointing authority, do possess the legal qualifications to be competent to adjudicate in matters, especially those affecting heavy penalties, as long as the UPDF Act that creates the General Court Martial does not expressly include legal qualifications as a requirement for appointment to the General Court Martial, that is de jure, the competence and capacity of that court to handle criminal trials would still be questioned as is being done in this appeal. This is based on the cardinal principle in our legal system that justice must not only be done, it must be seen to be done. The General Court Martial would only be competent to adjudicate over criminal matters of not only civilians but also military persons if it were a court of law with the requisite structures to conduct a fair hearing as envisaged under Article 28 of the Constitution of Uganda. There can be no fair trial as envisaged in Article 28(1) of the Constitution in an incompetent court. It is in that regard I would, with respect, not agree with the appellant's contentions that the General Court Martial is a court of competent jurisdiction to hear criminal matters. In its present state, the General Court Martial, though lawfully set up by an Act of Parliament deriving such powers from Article 129(1)(b) of the Constitution, is in its present form competent only to handle matters relating to discipline of members of the armed forces. In the results, based on the above, and in addition to the reasons, decisions, conclusions, and recommendations for legal reforms stated in the late judgment which I associate myself with. I would conclude that this appeal files, save for the issue regarding the establishment of the General Court Martial as a court of law. I would dismiss it to that extent and allow the cross appeal. I would award the course of this appeal to the respondent in this court and in the court.